Judgment in the matter of Dooneen Ltd and another versus Mond.
When a person is facing insolvency, instead of going bankrupt, he can enter into a voluntary arrangement with his creditors, if they agree. In Scots law, this usually takes the form of a deed granted by the debtor, conveying his estate, that's to say his property, to a trustee for the benefit of his creditors, and giving to the trustee the power to distribute the estate amongst the creditors. The deed will usually contain provisions relating to the discharge of the debtor, that's to say his release from his debts, and also the discharge of the trustee from his obligations once the estate has been distributed. This appeal concerns a situation of that kind. The trust deed provided that the trust was to come to an end on a final distribution of the estate, and that the debtor and the trustee would then receive their discharges. The trustee distributed the estate and submitted a certificate that there had been a final distribution for registration in the public register of insolvencies. The debtor was discharged of his debts, and the trustee was discharged from his obligations. Some years later, it was discovered that the debtor had in fact had additional property, which had not been distributed, and of which the trustee had been unaware. It's not suggested that the debtor concealed it, and he may also have been unaware of it. The property in question was a claim against a bank which had missold him payment protection insurance. The bank agreed to pay an amount in compensation. The question which arises in this appeal is, who is entitled to the money, the debtor or the trustee? The debtor argues that the trust came to an end when the trustee made his final distribution, and that he has therefore been discharged of his debts, and so no longer owes anything to his former creditors. That argument was upheld by the Scottish courts. The trustee, or former trustee, depending on how one looks at it, appeals to the Supreme Court and argues that there cannot have been a final distribution within the meaning of the trust deed, since what was distributed was not, in fact, the whole of the estate. If there was not a final distribution, then the trust has not come to an end, the debtor has not been discharged of his debts, and he, the trustee, is entitled to receive the compensation from the bank and to distribute it among the creditors. The Supreme Court unanimously dismisses the trustee's appeal. It holds that a final distribution within the meaning of the trust deed is a distribution which the trustee declares to be final. To hold that what was declared to be a final distribution might turn out not to be, years later, if additional estate was discovered, would have consequences that cannot have been intended. One could never be certain that any distribution was final, since the possibility of unknown estate coming to light could never be excluded. That would result in uncertainty as to whether the debtor had or had not been discharged of his debts, and as to whether property which he acquired after an apparently final distribution belonged to him or to the trustee. It would also mean that reliance could not be placed on the accuracy of the public register of insolvencies. The court adds, however, that this is not a satisfactory result. An asset which vested in the trustee, even though he was unaware of it, and which ought to have been applied to payment of the creditors, will instead be paid to the debtor merely because the trustee was unaware of its existence until after he had declared a final distribution. The court raises the question whether the relevant acts of the trustee might be set aside if they were the result of an error as to the extent of the trust estate. But the court does not answer that question, as the parties to the appeal declined to argue it, and the court cannot decide questions that have not been argued. The court will now adjourn.